Thank you very much.
Thank you, Chairman. I'm Danny Friedman. I appear here today with Liz Davis, and I speak from the group submission served on behalf of the core participants, represented by Bhatt Murphy, Bindmans, Hickman and Rose, Hodge, Jones and Allen, and Irvine, Thanvi, Natas. Those submissions, like all of the submissions today that are written, will be on your website. You've already referred this morning to the helpful agenda that was sent through by Bernberg Pierce, where a group of core participants, lawyers, who you're going to hear from, I think, till about 3:45 or 4 o'clock today, have divided up and distributed the matters that each of us will lead on to avoid duplication, but also to ensure that you hear different voices and different perspectives on behalf of the hundreds of people who lived, survived, and in 71 known cases died in Grenfell Tower.
So, Mr. Friedman, is it your plan to deal with the first item on what I've called the Bernberg's agenda?
I am going to deal with the purpose of inquiry and building confidence in its process, which is item 1.
Yeah.
The division between the so-called two phases and the task of taking statements from survivors and the bereaved.
Very good. All right, thank you.
Sir, with you as the chair, with your inquiry team, your assessors, and we hope some other eminent women and men who will sit with you on a panel, we are here to publicly find out why this tragedy happened and who or what was responsible. If I turn to the purpose of the inquiry, I want to focus, if I may, on Article 2 of the European Convention of Human Rights. You, sir, have previously spoken about the anger, frustration and the sense of injustice that our clients understandably labour under. Your counsel, in their public statement, have referred to the need to provide a voice to those who have been personally affected by the fire and to make sure that those who have suffered are fully involved. These sentiments are welcome and, of course, morally and rationally sound, but they also reflect the law of human rights. There are minimum requirements to investigate when an event of mass casualty and suffering occurs, especially one of these proportions. This is recognised at a European level in Article 2 of the European Convention of Human Rights. This inquiry is therefore required by Section 6 of the Human Rights Act to act compatibly with that law. So that there will be no misunderstanding, these rights are now recognised at a global level. The same rights can be found in Article 6 of the UN Covenant on Civil and Political Rights. They form part of customary international law, or the law of nations and all peoples. So Section 1 of the Inquiries Act 2005, which provides the foundation for this inquiry, is one of the means through which the United Kingdom will comply with that law. The basic requirements for an investigation will be known to the lawyers in the room. They may also be obvious as a reflection of basic decency and humane treatment. But let me recall, sir, those 5 core features, because everyone you hear from today, and quite possibly tomorrow, will no doubt be guided by them. The process must be 1, independent, 2, thorough, 3, public, 4, sufficiently transparent and inclusive to enable effective participation by the survivors and the bereaved, and 5, prompt. All of that must combine to ensure accountability and, where justified, attribution of responsibility. Because we're talking about rights, these are not mere rules that must be complied with, but foundational values that should be the anchor for the whole endeavour that brings us before you. Put simply, the survivors and the bereaved must be placed at the centre or heart of this process. That does not mean that you should be biased in their favour. They do not want that. And it does not mean that you should treat those who could be criticised in an unfair fashion. Far from it. But you must put the survivors and bereaved at the centre of the process, because that is where the law requires them to be. And one of the foundation cases for the proposition I just made is a case called El Masri and the former Republic of Macedonia. The Grand Chamber of the European Court of Human Rights adopts and endorses the restorative justice case law that was decided in the American Court of Human Rights in the 1990s, and refers to the victims and the next of kin as having the right to the truth. It is a right that they enjoy in their own capacity, and it is a right they enjoy as representatives of the public. Which marries up with a leading case in the United Kingdom, perhaps the leading case, Lord Bingham in a case called Amin in the House of Lords, where he said that the purpose of the investigative function is to ensure so far as possible that the full facts are brought to light, that culpable and discreditable conduct is exposed and brought to public notice, that suspicion of deliberate wrongdoing, if unjustified, is allayed, that dangerous practices and procedures are rectified, and that those who have lost their relatives may at least have the satisfaction of knowing that lessons learned from his or her death may save the lives of others. These purposes are not just about practical lesson learning and uncovering wrongdoing, but also we say something more profound. I am repeatedly told, and I have seen, that the overriding things that our client seek right now is a restoration of respect for their human dignity. That is to say that the task must not just be to discover technical matters that caused and spread this fire, but to promote the dignity and equality of those who have suffered from it. That is what the beginnings of justice would look like. They want the dignity that they have shown to be mirrored back to them. Which brings us to the question of how to build confidence in this inquiry and make it relevant to the recovery and raw grief and trauma of its central core participants. So that's not simply your responsibility or the responsibility of your council team. It's the responsibility of everyone who comes here before you. You cannot learn at school, college or university or any area of working life, law or otherwise, how best to conduct the Grenfell Tower inquiry. There is no substitute for being endlessly curious about what is required, most of all from the people who lived through it. And we've heard today, importantly, that there is sympathetic engagement with the matters that have been raised, and we are beginning a dynamic and open-minded conversation. But there are confidence-building issues, and we have set them out in paragraph 7 of our submissions, in the spirit that the best way to join forces in meeting those issues is to voice them and to work on their solutions. We called them 7 concerns. Let me call them confidence-building issues. Issue number 1 is that the bereaved, the people in grief who have suffered a traumatic and wholly unexpected loss, do not, as yet, have any formal recognised status in the process at all. I noted the words used today, but in the Counsel to the Inquiry's public statement, they were subsumed under the categories residents or those who speak for those who are unable to participate in the inquiry, which means that they are not as yet properly recognised as persons entitled to effective participation in their own right. Given all that I've said to you about the fundamental human rights legal framework, you could say something quite soon which would make a tangible difference in terms of promoting the dignity of that situation and assisting their grief. But there's a more formal issue to resolve, if I may. The inquiry must fulfil the function of the inquest. The setting up of an inquiry produced an important public debate about the difference between the 2 types of proceedings. The reason why it was important to have a public inquiry is that it is capable of conducting a broader investigation than an inquest and resolving more issues. That said, it would be terrible if at the end of this process the inquiry had not done what an inquest would do, which is to record who, how, and in what circumstances each person died. However you structure the phases or modules or whatever we will call them, by the end of them, We would not want bereaved families to have to go through an inquest in addition to what you have done. The inquests have been formally adjourned, but Article 2 of the Convention requires the investigation, whatever form it takes, to be conducted promptly. The inquiry, therefore, must complete this work. Sir, today, I'm standing before you on behalf of 62 bereaved relatives relating to 47 deceased people, of which 10 were children. And as a matter of law and basic compassion, those people need to know that they will not have to go through another process after this. Confidence issue number 2 is that the core participants will be treated as mere vehicles for providing evidence and their crucial participatory role marginalised. Your counsel have in writing said they want them to be fully involved. They've said it again today. But how the full involvement will work in a manner that is effective, equal and inclusive is what we are now here starting to design. But if your team, and I say this with respect, but it needs to be said to be resolved, if your team writes letters asking for views on any matter, be it experts, the law or procedures, none of us will reply until we are satisfied that we can do so on instructions from our clients. We serve our clients, they don't serve us. In Mr. Steen's words later on, this cannot be, or seem to be, a mere conversation between lawyers. Confidence issue number 3, disclosure. The fear is that it will be late, limited, and with insufficient funding or time to read and consider. Now, Mr. Weatherby will address this as an issue in detail later. For our part, it's essential to add that there should be at least preliminary disclosure of general materials and what you call materials from phase 1 and phase 2 as soon as possible. We do not need to wait for everything to begin, and what can be made available while we wait for everything can be done in tranches. In the annex of our submission, we have isolated by way of draft suggestions some core items, such as the housing files, which I'll come to if I may, 999 calls and emergency response logs, that would enable everyone to begin. That list is a draft work in progress. We have also seen a helpful breakdown of the standard emergency response documents provided by the Fire Brigade Union in the core submissions for today, and that makes clear what could be disclosed to all parties near enough straight away. So with group discussion, we can work with your team to enable everyone to start on these core materials soon. One of the things that is aggravating the suffering is delay. So the sooner the disclosure can begin on some things, the quicker some of that aggravation can be manoeuvred.
Is that something on which discussions with the inquiry team could take things forward?
Indeed, I believe they could. I don't, on my feet, want to design the discussion-taking process, but I think I can speak for many representatives of core participants that for us to work together and, of course, consult with our clients while those discussions go on would take things forward, I believe.
Yes, thank you.
Confidence issue number 4, please. Hearings will be conducted exclusively by your counsel and you, rendering the core participants passive attendees, able only to give their own evidence if asked, and to suggest questions, but never to ask them. Well, we want to ask questions on behalf of our clients. That could be done at an inquest, so it should be done here. But it must also be done in a way that saves time and avoids repetition. And yet there will be occasions when someone might wish to ask questions on the same point from a different perspective. Sometimes we will seek to test controversial evidence ourselves, and sometimes, sir, we will want to give a client the experience that the lawyer they trust was able to ask a question that is essential to them, something that goes to the heart of their grief. From that, can I just deal with the issue of witness statements and giving evidence? Because in this context, we and the barristers are going to follow on from me, are assisting the bereaved, survivors and ordinary local people who knew how unsafe the building was as of that night and tried to make a difference. None of them are state agents or employees or leaders of corporate organisations. They do not have a system, union or company to support them. Many of them are in acute need of support because they were left with nothing save often physical and psychological injury. Both Sam Steen and Fiona Murphy are going to add to this later. We've dealt with it in paragraphs 11 to 13 of our submissions. Just briefly, first point is that the aim to publish a permanent testimony of what has been lost by the tragedy is hugely valuable. Secondly, we understand that the inquiry wants statements from the residents regarding the fire itself, but that there will be flexibility to supplement those statements in relation to any fresh evidence disclosed and in relation to later issues that will be dealt with. Thirdly, there will be different ways to give and publish our clients' evidence, including providing special measures for video link or perhaps playing a video statement, and pastoral care for witnesses that need it inside an inquiry room and outside. Fourthly, there needs to be agreement about the provisional disclosure, which we've already touched upon, to make sure that clients are not giving an uncited account without the basic assistance of seeing the emergency logs, the 999 calls, the videos, etc. I want to say something about housing records. In social housing, the housing file is an essential record of who that resident is and who is in their household. It details their personal characteristics, age, disability, children, and everything about the people who are living with them. So it helps us to know our clients and advise them, but it helps you to know who was living in Grenfell Tower as of the night of the 14th of June. It's not the complete answer, you know that, but it is an absolutely fundamental answer. And this has been touched upon by those who instruct me, and other solicitors have spoken about it. The statements, even if, in Mr. Millett's helpful description, they are a narrow first attempt that can be preliminary, can be held off to deal with what happened on the night, are nevertheless capable of being referred to in later criminal proceedings, civil claims, housing proceedings, and others may have to deal with them in immigration proceedings. It's not right, therefore, to ask people to give an account about the most significant night of their lives whilst they are still in trauma without their lawyers having access to this basic information and without them being sufficiently informed in order to give the appropriate advice. Fifth point on statements, and Mr. Steen in particular will develop this. So I think you'll be surprised, as others have been, about how challenging it is to take the statements and the need to provide a great deal of care to the people who are being asked to give them. On a very provisional basis, taking into account the unknowns, etc., we've written to you separately to say that 2 days per core participant is at least what is needed. And after the disclosure has taken place, at least for the first tranche of statements, it's going to take about 8 weeks. It would be wrong to become concrete today, but it gives you a ballpark figure. Confidence issue number 5. The inquiry will get bogged down in the technical question of how and not move quickly enough to the question of why. And this is relevant to whether an inflexible division of phase 1 and 2 with an enforced hiatus in order to produce an interim report would be positively counterproductive. Now, Mr. Mansfield's going to take this up, but in headline form, there are 2 potential problems. 1, delayed reporting on matters relevant to fire safety in tower blocks, and 2, artificially investigating the response of the fire brigade by separating key issues of how and why between two phases. We've dealt with this in our submissions at paragraph 15 to 17. It is noteworthy that both the Fire Brigade Union and the London Fire Brigade are concerned about the exact same artificiality of the split. Can I just make two observations about this? Firstly, the firefighting strategies on the night do not logically, in many cases, fit into phase 2 on the current plan. And there are some obvious omissions, most significantly being the fatal effects of people being told to stay put once the external parts of most of the building were ablaze. The second thing to add, it is important with respect for you, sir, to keep an open mind about how and when the inquiry can report on technical issues or otherwise make provisional observations about matters arising from the evidence. The advantage of the public inquiry mechanism is that you can do that in different ways at different times. So the discovery of dangerous material or the existence of a dangerous practice does not require you to wait for the end of phase 1 or indeed phase 2 in order to act, nor must the state and corporate core participants necessarily wait themselves. There are many instances in inquests and inquiries where the authorities serve statements saying they have already decided to change a practice and explain why. So you could make their change of practice public and provide provisional endorsement as to why you agree with their stance from what you presently know. Equally, when your council make opening statements or other state or corporate core participants ask to open themselves, they could invite you to reach a certain conclusion immediately. And furthermore, if you reached a decision that something was unsafe during the course of evidence, then you could issue a provisional analysis to that effect and invite submissions or carry out a focused hearing to discover whether you were wrong. So coroners, under their legislation, can produce prevention of future death reports at any time, and accordance submissions from those who were responsible or involved in those recommendations would be heard before they were finalised.
So is your message, keep it flexible and see where the investigation leads and report on important things as and when you come across them?
Indeed, and if I may say so, and I don't want to go into any example now today for obvious reasons, but if there's an elephant in the room, you should just say it's an elephant rather than spending 3 to 4 weeks talking about something with a long trunk, tusks and the like. Please don't let phases delay you in declaring the obvious or using case management powers to narrow the issue so that we get to the why. Confidence issue number 6 of 7, nearly done. The human experience of the core participants, including their backgrounds, their difficulties and their suffering, will not be properly understood. We have to get to know our clients so that we can enable you to know them. That's our job. But they have to have the confidence and trust in the process in order to believe that the difficult work that they will be asked to do is both worthy and relevant to their recovery. Others are going to address you on extending the diversity and inclusiveness of the panel. Mr. Mansfield, Mr. Thomas and Miss Munro. There can be little doubt that to do so would have a paradigm-shifting positive consequence in terms of confidence. There are lots of different reasons to explain why that is so. Grenfell Tower was a beautifully diverse place to live. Diversity improves the quality of any institution, but especially a public inquiry committed to hearing those diverse voices. Justice is not just about outcomes. It's also about the process and journey that gets you to the outcomes. And then please recall why this inquiry was established in the first place. To allay acute public anxiety that concerns had gone unheard and uncared for. The question, therefore, is not what an objective, informed bystander would say about you as the chair. being able to reach independent findings. That's the wrong question, if I may say so, not one that I raise. The right question for the objective informed bystander to answer is what, in this extraordinary situation of loss of confidence and mistrust, would be justified to restore those very things? To which the answer would be, the fire was a disaster of mass fatality, near death, homelessness, and people left destitute. The inquiry into the fire not only deserves the chairmanship of an eminent retired senior judge, it deserves more. Confidence issue number 7. And to conclude, a process that could provide transitional justice will become irrelevant to and even hinder the core participants' post-trauma recovery. Well, much of that has been dealt with, what I've said, on issues 1 to 6. So I realise that it may be daunting, but as a judge, you're being asked to be more than a judge and to decide more than a case. And that is why the solutions suggested by your counsel and in the various submissions before you today are so important to get right and to correct if original decisions prove not to be the best ones. We are not in litigation, we are building an inquiry. So what people want is something that can be a proud and positive example of justice and equality in 21st century Britain, a lodestar of dignity, if you will. And there is no false promise or naivety in making that the aim that guides us all. Thank you.
Well, thank you very much, and some very good points to think about there. Thank you.